When can an employer legally deny FMLA leave? Imagine needing time off for a serious health issue or to care for a family member, and wondering if your employer can say no. It's a common question, and the answer depends on specific rules. First, an employer can deny Family and Medical Leave Act leave if the employee does not meet certain eligibility criteria. To qualify, the employee must work for a company with at least 50 employees within a 75-mile radius. They also need to have worked for the employer for at least 12 months and have logged at least 1,250 hours during the 12 months before the leave request. If these conditions aren't met, the employer can refuse the leave request. Second, if the employee is requesting leave for a serious health condition, they must provide proper medical certification from a licensed healthcare provider. If the employee fails to submit this certification on time, or if the certification is incomplete or doesn't support the need for leave, the employer can deny the request until the correct documentation is provided. Third, FMLA allows for up to 12 weeks of unpaid leave in a 12-month period. If the employee has already used all 12 weeks, the employer can deny any further leave under FMLA. It's important to keep track of how much leave has been used to avoid misunderstandings. Fourth, employees are generally expected to give notice of their leave in advance, especially if the leave is planned. If they do not provide enough notice or fail to communicate the need for leave properly, the employer can deny the request. This helps the employer plan for staffing and operations. Fifth, sometimes employers may dispute whether the employee's condition qualifies as a serious health condition under FMLA. They might also challenge whether the employee's role or eligibility status fits the criteria. If the employer's interpretation aligns with FMLA rules, denying leave on these grounds can be lawful. Lastly, in very rare cases, an employer might deny reinstatement after FMLA leave to a key employee, someone in a high-paying role, if returning would cause significant economic harm to the business. However, this does not mean the leave itself can be denied, only the return to the same or an equivalent position. It's important to remember that employers cannot deny FMLA leave based on retaliation, discrimination, or to discourage employees from taking leave. Doing so is against the law and can lead to legal trouble. In summary, an employer can only deny FMLA leave if the employee isn't eligible, doesn't provide the required medical certification or notice, has already used up their leave, or in very limited cases involving key employees' job reinstatement. If an employer denies leave unlawfully, the employee can file a complaint with the Department of Labor or pursue legal action.